G'day again, and welcome to the third video in week 6 of our admin law course. So far this week we've been looking at the concept of narrow ultra vires, which boils down to 3 propositions. If you can't show where the legislation authorises a decision, the decision will be invalid. If the legislation requires procedures to be followed before a decision can be made, then a failure to follow those procedures will invalidate the decision. And finally, a decision can only be made by the person nominated in the legislation or by their proper delegate. In this video, I want to take half a step to the side. We're going to be talking about a concept called jurisdictional error of law. Jurisdictional error of law is very similar conceptually to the narrow ultra vires stuff we've been talking about this week. It overlaps a lot. So some of what I'm going to say in this video will sound really familiar. At the same time, jurisdictional error of law goes just a little further than narrow ultra vires. And it's a really important concept for reasons that I'll explain later on. The explanations would make no sense right now, so you just have to trust me for a few minutes. Before we get into it, I want to tell you up front that many students struggle to wrap their brains around jurisdictional error. So if this takes you some effort, that's a-okay. It took me some effort too when I was an undergraduate. I promise you though, this really is important enough to justify the time. I want to start with one of my really simple, silly, family-based pretend scenarios. I want you to imagine a parent who has 2 children, a 15-year-old and a 10-year-old. The parent has to go out for a couple of hours, leaving the 2 children at home alone. Now, at law, a 15-year-old is perfectly able to supervise a 10-year-old. The parent puts the older child in charge and says, if your little brother wants to turn the TV on after midday, then you can let him as long as the show he wants to watch is suitable. Now, that's a decision-making power, isn't it? The older child will have to decide whether the show the younger child wants to watch is suitable. But the older child can't just make that decision. 2 conditions have to be in place first. First, the younger child has to ask. This is the household equivalent of someone making an application. If the younger child decides that they're having too much fun kicking a ball around in the backyard, then the older child's views about the suitability of TV shows is irrelevant. Until there is an application, a request by the younger child, the older child has no jurisdiction to decide anything. Second, it has to be after midday. If the younger brother asks for the TV at 11:30, the older child has no power to say yes. Doesn't matter if the show is suitable or not. The decision-making power of the older child doesn't exist yet. Again, the older child doesn't have jurisdiction. A jurisdictional error of law happens whenever someone tries to make a decision and they don't have the power to make it. In general, there are 4 types of jurisdictional error. 3 of them are our narrow ultra vires grounds. First, does an enactment provide the power to make the decision? In this case, Mum was the legislature. The power to decide the suitability of the TV show existed because she made up the rule. That's the equivalent in household terms of an enactment, isn't it? Second, if the enactment sets out a procedure to enliven the decision-making power, the procedure must be followed. So if the younger kid doesn't ask to watch TV, the procedure does not get followed. So the power to decide the suitability of the TV show doesn't arise. Third, who does the enactment give the power to? Mum gave the power to the older kid. If the older kid delegated that power and told the younger kid to watch whatever he liked, the younger kid's decision would have no validity. And fourth, this is the new one, there may be another precondition. Not a procedure, but some other condition that needs to be present to enliven the decision-making power. We call these jurisdictional facts. In this case, the precondition, the jurisdictional fact, was the time. Until midday, even if there was an application by the younger kid, and even if the show was suitable, there was no power for the older kid to make the decision. Let's bring it back to the law. Jurisdictional error of law occurs if 1. The decision is not authorised by the enactment at all. 2. The decision maker was not authorised to make the decision. 3. If a procedure had to be followed before the decision could be made and the procedure was not followed. And 4. If some other non-procedural condition, some jurisdictional fact, had to exist before the decision could be made and that jurisdictional fact did not exist. In any of those cases, the decision maker never has the power to make a decision. They never have jurisdiction. And so if they try to make a decision, they're making a jurisdictional error. In a recent landmark case called Hossain and the Minister for Immigration in the High Court, Chief Justice Kiefel and Justices Gagler and Keane said, jurisdictional error, in the most generic sense in which it's been come to be used to describe an error in statutory decision-making process, correspondingly refers to a failure to comply with one or more statutory preconditions or conditions to an extent which results in a decision which has been made in fact lacking characteristics necessary for it to be given force and effect by the statute pursuant to which the decision maker purported to make it. To describe a decision as involving jurisdictional error is to describe that decision as having been made outside jurisdiction. Now that's a long, dense quote. Go and have another look at it once or twice, but it really does completely capture the heart of what I'm talking about when I talk about jurisdictional error. The next question, of course, is why any of this matters. For the longest time, this was just a technical distinction. Nobody genuinely cared about the difference between jurisdictional and non-jurisdictional error, unless maybe they were an administrative law lecturer. But then in 2001, the Tampa incident happened. We've already talked about that one. That was the case where the container ship saved the refugees from drowning, but the Australian government refused to allow them to dock in Australia. Shortly afterwards, in October 2001, the Howard government falsely accused a different group of asylum seekers of throwing their children overboard in order to oblige the Navy to rescue them. The entire 2001 federal election was based on racist hysteria, with the Howard government promising to make it more difficult for Muslim asylum seekers to reach Australia. As part of that process, the government passed privative clauses to try to prevent asylum seekers from being able to challenge immigration decisions. Regardless of your views about refugees and immigration, this was tragically unjust. The accountability mechanism of judicial review was removed from refugee decisions simply because the government wanted to make the process harder. The High Court came to the rescue. In a case called Plaintiff S157 in the Commonwealth, the High Court determined that its power to review jurisdictional errors of law comes directly from the Constitution, and as a result, the Parliament cannot prevent the Court from reviewing administrative decisions where there is an allegation of jurisdictional error of law. So while an aggrieved person might be prevented from complaining that a decision was made incorrectly, they cannot be prevented from challenging the decision if their allegation is that the decision maker lacked the power to make the decision at all. As a result, there are still bucket loads of migration review decisions every year. The government failed in its attempt to put migration law beyond the jurisdiction of the court. That's the take-home message. Administrative decisions which suffer from jurisdictional error can be challenged in court, even if there is a privative clause to the contrary. And thank goodness for that, because any government which tries to legislate away your right to challenge administrative decisions is trying to legislate away your basic human rights. So that brings us to the end of week 6. This week we've looked at narrow ultra vires and we've looked at the idea of jurisdictional errors of law. We've learned that an administrative decision is invalid if there is no enactment to provide the decision-making powers. The decision is invalid if the decision maker is not authorised to make the decision, either by the enactment itself or by a valid delegation. We've learned that the decision is invalid if the legislation requires certain procedures to be followed before the decision-making power comes into existence, and those procedures are not followed. Those three are our narrow ultra vires. Finally, we've learned that decisions are also invalid if the legislation requires some precondition, some jurisdictional fact to be in place for a decision to be made. And if the precondition or jurisdictional fact is not in place, the decision can't be made. Those four grounds for review are all jurisdictional errors of law, and the government can't just legislate them away. Yet again, administrative law is our protection from tyranny. Next week, we're going to hook into the rest of the grounds for review, what they refer to as broad ultra vires. For my money, next week is the most interesting week of the whole course. Have a great weekend, and I'll see you next week.